Welcome to another episode of the Legal Gym Podcast, where we provide practical tips and strategies to help you start, build, grow, and, of course, legally protect your own online business. And now, here's your host, trademark lawyer Jim Hart.
Thank you so much for listening in on today's episode. Before we get to the content, I just want to give you a quick reminder that although I am a lawyer, I am not your lawyer. Nothing I talk about in today's episode should be construed as legal advice of any kind. So if you have questions about today's topic and how it might apply to you or your unique situation, your best bet is going to be to contact a lawyer in your city or state. All right, now we got that covered. Back to the episode. Hello and welcome to another episode of the Legal Gym Podcast. Thank you so much for joining me today. Today we're going to be talking about a framework that I've developed to increase the likelihood that my clients' trademarks will actually get registered as quickly and easily as possible. Now, for the show notes for today's episode, which will include all of the links and resources for everything that I'm going to be discussing today, make sure you head on over to hawthornelaw.net/framework. That's hawthornelaw.net/framework, one word. All right, now let's go ahead and dive in. If you are just getting started in business, or maybe you've been in business for a while and you're thinking that maybe you should take some time to actually protect your intellectual property, and by intellectual property, I mean trademarks. That's what we do, and that's all I do, and I really enjoy doing it. You want to make sure that you do it the right way, however. And so I've come up with a framework, I call it the 4R framework, to help my clients make sure that we get their trademarks registered and get them registered very, very quickly, as fast as possible. And before I get into this framework, I think it's helpful to kind of explain what trademarks are and how they work, because a trademark is basically what identifies your brand in the marketplace. And a lot of people think that they don't actually have any trademarks, because if I ask a group of people who here has a trademark, a few people might raise their hand, and those are the people that have actually gone through the process that we're going to talk about today and actually registered their trademarks. But many people in the room will likely not raise their hands. And the reason they don't raise their hand is they don't understand that everybody who's in business, who's selling something, whether it's a product or service, could be your overall brand, it could be anything, likely has a trademark, because trademarks are not something that are limited to federal registrations. There are what are called common law trademark rights. And a lot of people think, again, foolishly I might add, that by common law rights, they have just as many protections as they would have if they registered their trademarks with the Federal Trademark Office, and that's just not the case. Common law rights for trademarks are actually quite limited, and they're usually limited in scope to the geographic area where you live in. So if you open up a mom and pop store of some kind and you pick a great name to name it and you put it in a street in your hometown, then chances are, and you let's say you open up a coffee shop, because who doesn't like coffee, and let's say I call it Jim's Coffee, which is interesting because I think in San Diego there's actually a brand called James Coffee, so probably trademarked also. But anyway, let's say I named a coffee shop and I wanted to call it Jim's Coffee, and that was not going to infringe on this James Coffee that exists in San Diego and probably nationwide too. Then if somebody else wanted to open up a coffee shop across the street from me and call it Jim's Coffee, then they would not be able to do that, because I would have common law rights to that name, and that would protect my small little area of the town where I live. It could protect, maybe if I'm in a bigger city, the city where I live. It could even protect me on a county level, but it's probably not going to do much more than that, because if somebody lived 4 or 5 hours away in another city, whether in the same state or not, and they wanted to open up a coffee shop called Jim's Coffee, then nobody's going to know about my coffee store. And so the potential there is that they would not be infringing on my common law rights, but they could, and it really depends, and every case is unique. But to make sure that I have the rights to that coffee store that I want to call Jim's Coffee, and to make sure I have the rights to that brand, and that I can create merchandise surrounding that brand, and that I can create a line of coffee surrounding that brand, and franchise that store, and open that store in multiple locations in different cities and states, then it's going to be important that I actually follow the process I'm going to talk with you about today and actually register that name as a trademark with the U.S. Patent and Trademark Office. So that's why it's important, is because if you really want to grow and take your business to the next level, then you need to make sure you're taking your trademark seriously. And so my 4R framework is how we're going to help you do that. And so I have 4 parts of this framework. Obviously, it's called the 4R framework. And step number 1 is research. Step number 2 is ready. Step number 3 is respond. And step number 4 is register. That's research, ready, respond, register. And I'm going to talk about each of those here today. Let's start with number 1. Number 1 is research. And this is probably the most important part of the process. This is the part of the process that I spend the most time on with my clients. What we do during the research phase is, number 1, we confirm that the name that my client wants to use is actually a name that's capable of being trademarked. In other words, it's not too descriptive or too generic for what it is they're selling. And then in addition, we will look at the marketplace and determine if anyone else is selling a name that's the same or similar to the name that my client wants to register. And we do that by looking at the USPTO database. We look at the state databases. We look on the internet and see what else is out there in terms of social media platforms, in terms of like Amazon and places like that. And we do a pretty comprehensive search report for our clients that kind of let them know the lay of the land with regard to the mark that they're looking to register and whether or not I think, in my legal opinion, they are capable of registering that trademark. And if they're not capable of registering that trademark, then I will tell my client and I'll give them advice and guidance on what I think they should do, whether it means changing their name or rebranding entirely. And my advice to clients at this point is going to vary greatly depending on the client, because some clients have been using the same name for years and years and years, and they don't want to rebrand and they just want to register the trademark. Even if I find something that might be deceptively similar to theirs, they still want to push forward. Other clients are just starting out and they're open to a rebrand if I find something that is going to be problematic for them. So that's step number 1, research, because the last thing we want to do, and this is why this is so important, is the last thing we want to do is spend months and months of time and money investing into a brand that ultimately, at the end of the day, you're not even going to be able to get as a trademark. And if you do that, that's just a problem. It's just waiting for the other shoe to drop, as we like to say here. So researching the trademark at the very beginning is the most important part of this process. And that's why we make that step 1 of the 4R framework, is we want to do comprehensive research to make sure that the name that my client has chosen or that you've chosen is actually going to be available. From there, the step number 2 is ready. That means we are readying the trademark application. I realize this sounds a little weird. It probably would have been easier to say file the trademark application, prepare the trademark application. I said ready because otherwise it doesn't mesh with my 4R framework. And so I said ready the trademark application. So ready means that we want to prepare that application. It means we want to help our clients make sure we have the proper ownership set up for the trademark. So do they have an LLC that they need to set up, or are they going to be doing it as a sole proprietor? I help my clients understand the distinctions and what that means and determine who is going to actually own the trademark. We talk about the different classes that they're going to be selling in for the trademark. We talk about a description of the goods and services that might be selling. And we make sure that we have all that information together so that when we prepare and submit that trademark application, it's going to increase the likelihood that my client is going to have success on the merits of that application. The other thing we're going to want to do is, if my client is currently selling, we will prepare specimens showing how my client is using the trademark in commerce. So specimen is basically evidence that we submit with the application to let the trademark examining attorney know that we're actually using the mark in commerce. Or if the client is intending to sell under that trademark but is not currently selling under that trademark, then we'll talk about the implications of filing what is called a 1B application, which is an intent to use application, and submitting that statement of use or allegation of use later on during the process. So that's step number 2, is we're going to ready the application and actually submit the application. From there, my clients and anyone who's filing a trademark right now will find out that you're actually going to be waiting quite a bit of time. The current wait time, according to the trademark office, is around 8 to 9 months. And I've got clients who filed their trademarks last September. And let's see, so if they filed in September, Yeah, so we should be getting responses back on some of those applications, I would say this month, because it's now May as I'm recording this, but it's taking a long time to get any type of response back from the trademark office. I've heard some people waiting as long as 11 months right now to get a response back from the trademark office, but that's the next step of the process, is responding to whatever it is that we get back. Now, I will tell you around 50 to 60% of all trademark applications are going to receive what's called an office action. Now, what is an office action? Well, when you file your trademark application, it gets put into a queue, and eventually it will get assigned to a trademark examining attorney. And what that examining attorney will do with your application is they will do a search for your name, and they will determine whether or not your name is, number one, capable of registration, and then number two, they will do a search to see if it's likely to be confused with any other trademarks that currently exist in the USPTO database. And that could be active trademarks that are registered, or it could be pending trademarks that were filed before your application. That's the way it's supposed to work. And 50 to 60% of all trademark applications will receive some sort of office action back. And what that office action is, it's either, well, let me take a step back. I think I mentioned the examining attorney can do three things when they receive your file. They can either approve your file for publication, they can ask you for more information on your file, or try to make some adjustments to your description, or they may ask for a new specimen or do something like that. Or they can issue what's called a substantive denial. Those are the three things they can do. And unless they send the application straight through to publication, if they're asking for additional information or issuing a substantive denial, those are called office actions. And so they will submit an office action, and you will have 3 months to respond. It used to be 6 months. They recently changed the time frame to 3 months. And this is where most people who file trademarks on their own run into problems because they aren't sure what to do. They aren't sure how to respond, and they just kind of give up and they abandon their trademark. That's what happens with a lot of people that file their trademark applications as what we call pro se applicants. So about 50 to 60% of people who file trademark applications are going to receive some form of office action. At this point, our job is to respond to that office action as quickly and as thoughtfully as we possibly can. If it's a non-substantive action, if the examining attorney is just looking for some edits or changes to the application, or a disclaimer, or some sort of change to the description of the goods or services, that's something we can respond to fairly quickly. But if it's a more substantive denial, then we actually have to spend a little bit more time, and it usually takes 8 to 10 hours of attorney time, sometimes more, to draft a substantive response to that office action and rebut the issues that the trademark examining attorney has cited as a problem. Now, hopefully at that point, we will be able to overcome any denials, and the trademark can go forward to the registration process. But in some cases, another office action will issue on some other issue, or something that the examining attorney did not find originally when they filed or when they first submitted the first office action. That can happen. So there actually could be multiple office actions on a file, and we need to respond to all of those and resolve all those office actions so that, hopefully the application will move forward to the next stage, which is the registration stage. Now, I will tell you, there's one other thing that happens here before your mark is registered, and that means it has to go to publication. What does that mean? It means that it's going to be published, and this is an opportunity for anyone who has issues with your trademark. It's kind of like the speak now or forever hold your peace stage of the process. If anyone has an issue with your application and it's gotten to this stage, they can file what's called an opposition proceeding. It doesn't happen very often, maybe about 1% of the time, but if it does happen, it could be problematic, because normally what happens is these are from larger corporations that have a lot of money behind them, and they are sometimes acting as what I would call trademark bullies. And so at this point, we either need to negotiate a resolution of that or abandon the trademark application. Unfortunately, it does happen in some cases. But that is the next step of the process as it goes through publication. And then ultimately, your trademark will register. Once everything is complete in your file, all office actions have been responded to. If you filed a specimen and a statement of use and you're using the mark in commerce, it's going to register. If you're not currently using the mark in commerce and you filed an intent to use application, then this is the point where you will get what's called a notice of allowance, which means that you can start using the mark in commerce. And once they have accepted appropriate proof of your use of the mark in commerce, then your mark will register. So Once your mark registers, now that's not the end of the game here. From there, you must monitor your trademark. You need to make sure nobody files trademarks that are deceptively similar to yours and oppose those if necessary to keep your intellectual property safe. And then you have to file the appropriate renewal paperwork that comes at 5 and 10 years, and then every 10 years after that. So that's my 4R framework. That's how I help my clients to make sure their trademarks get approved quickly and efficiently. And it is a large process, and there's a lot of areas where things can kind of go off the rails in the middle, and we need to make sure that we address all those. And if you're doing a trademark on your own, if you're trying to protect your intellectual property without using an attorney, I honestly will tell you, it is going to be a really hard thing to do. Now, are there people out there that file an application and it gets approved and goes through and they get a registration without any problems? Yes, that happens. But I can also tell you about people that do that and then don't realize that they mess something else up with their application that causes problems down the road. I've seen that happen as well. Now, before we end today, I want to tell you about my new trademark book. Right now, I'm in the process of writing a book that's going to give you all the legal information and practical information you need to pick the right name for your business, register that name as a trademark with the USPTO, and then use that registration to leverage your brand and increase the value of your business over time. If you would like to receive special early access to the book, as well as previews of the book chapters as they are finished, head on over to hawthornelaw.net/mark. That's hawthornelaw.net/mark. And I'm happy to email you updates about what's going on with the book. All right, all you Legal Gym listeners, now that you know more about our 4R framework to get your trademarks registered and protect your brand, you are ready to implement, because if there's one thing we love to do over here at the Legal Gym, it's to take massive action. So if you haven't already, make sure to check out the show notes page for today's episode. You can get a rundown of all the links and resources we talked about here today by visiting hawthornelaw.net/framework. That's hawthornelaw.net/framework. And that's going to be the home base for all of your legal and business tools and resources to help you start, build, and of course, legally protect your very own online business. Thank you so much for listening today, and I look forward to seeing you or talking with you in the next episode.